in our final week of the Hot Topics lecture series. Today I'm pleased to welcome Adell Amos. She is the Clayton Hess. We love these named professors. The Clayton Hess, R. Hess, Professor of Law and the Associate Dean for Academic Affairs. On top of that, she is the Director of Clinics at the University of Oregon School of Law. In 2008, she was recognized for her expertise in water resources law and policy and accepted a 2-year appointment with the Obama administration as the Deputy Solicitor for Land and Water Resources at the U.S. Department of Interior. And she previously worked as an attorney advisor and served as the national lead on water and natural resource issues in the Office of the Solicitor, Division of Parks and Wildlife, where she represented and advised the U.S. Fish and Wildlife Service and the National Park Service and state and federal water rights and water management issues. She has published broadly in the field of water law, including a forthcoming book entitled Resolving Water Conflict. You seeing a pattern here? Water, water, water. She earned her BA from Drury College and her JD from the University of Oregon. And she is, this summer, our 2016 Distinguished Environmental Law Scholar at Vermont Law School. Today she's going to present on Drought in the American West, Reflections on Law, Policy, and Science. And because she's going to be talking about drought, and because there was a special request for a poem, I found one on the antithesis of drought, Rain, by Sander Wheelers. We had some yesterday, so you can really imagine this. The rain's pounding away at the rusty eaves, twirling, sliding, bubbling foam. Well, that's rain. You too and I should walk now, as free as that, on cloud, on air, the meadow, and the vapor roads. Move around up there and here below like this liquid thing, flowing into human life, on rooftops and on shoes. With that, join me in welcoming Professor Adell Amos. Just a second.
Good morning. Thank you. It's really an honor to be here. I, in particular, want to thank Melissa Scanlon and Mark for the poem, among other things, and Mark Mahaly, John Echevarria, David Mears, Lawyer Restrino, and others here at Vermont Law, for such a warm welcome for the 2 weeks that I've been here, and also for just being such great colleagues. I don't know if those of you who are in Vermont appreciate this about the group of people that are assembled here at this law school, but they are some of my favorites to work with, and they just capture the spirit of environmental law and the work that I got into teaching to do so profoundly that it's just really an honor to call them colleagues and friends in the academy. And of course, I want to thank Courtney Collins for her tremendous work in making all of this happen for me and my family this summer. It's really been a treat. I'd also like to say hello really quickly because I think there are a group of folks in Oregon who are watching live, so I don't know where I should look. Okay. Remember what I said? I don't know where I should look, but hello to those of you from Oregon. And lastly, I just want to introduce one special guest. My daughter Ella is in the back row in the purple sweatshirt, and she wanted to come and hear my talk on water law today, so it's really great to have you here, sweetie. She also gave me lucky earrings and her lucky rock that's in my pocket. So thank you, Ella, for being here. I want to do 3 things today, because I'm a lawyer and lawyers do things in 3s, and then leave some time for questions and conversations. First, I just want to provide some data and set the stage for why drought law, as it has come to be called, is a growing concern and has captured the attention of so many policymakers and lawyers nationwide and around the world. I have some slides and some maps and graphs that I think demonstrate really profoundly the challenges we face in the Western US, and that's just a microcosm for challenges I think that are faced around the globe. Second, I want to provide a little legal and policy context for this area of law that's come to be called drought law. Now, for me, I don't really think this is a separate area of law. This is really just water law in the face of regular, anticipated, and persistent shortage and change to the hydrologic system. It is requiring us to access provisions of water law that we haven't needed to access in the past because we haven't had regular, anticipated, and persistent shortages like we are seeing now. I'll talk about this by giving a quick summary of riparian and prior appropriation law. I can't resist. I teach this year-round. The two systems for allocating water rights in the U.S. and focus in particular in these two systems about how they respond to scarcity and shortage. Finally, I'll just close with some overarching themes and observations that I think help to frame our collective response to this problem. To preview where I'm going, I'd like to ask all of you to think about what I think of as a pretty basic question as we work our way through this material. And that is, what is the role of law and policy, and in particular government, as we navigate through these dramatic changes to the climate and the water system? I'll come back to this when I close, but I believe that now more than ever, we need government and law and policy to work for the people and the resources it was created to protect and manage. As we take a look at this data and at the legal and policy infrastructure that is set up for us, I would like for you to think about your sense of how we can make these systems respond to the needs we face. And then, if there's time, which I doubt there will be, I'd love to talk just a quick minute about this 10-year interdisciplinary NSF-funded modeling project that I've been a part of called the Willamette Water 2100. It's a coupled human and natural systems water model that looks at water availability and scarcity in the Willamette Basin out 100 years. This model is so exciting for me as a lawyer because the model not only has hydrologic data and socioeconomic data built into it, but law is built in. Typically, when hydrologists have built hydrological models, they treat law as fixed. Law is not a variable in how the model changes over time. This model is really different because there are levers, there are data inputs that allow you to change the law. So as I talk about some of the ideas about how prior appropriation can respond to scarcity, this model allows us to look at what that does in the context of the hydrologic system. So it's really it's been the highlight of my professional career thus far to work on this project. But let's start with some maps. And as you're gonna see, I love maps. The first few I'll show you are from the National Climate Assessment. For those of you who don't know, the Global Change Research Act of 1990 created the U.S. Global Change Research Program. This program has generated 3 national climate assessments to document data and the impacts in the United States from climate change and highlight areas of concern and research focus. So these reports have been very foundational, sort of setting up like the research agenda that gets established, for example, with this NSF-funded research that I've been a part of. The first was in 2000, the second in 2009, and the most recent was 2014. The 2014 National Climate Assessment was the result of many teams of experts, including representatives from 13 federal agencies, including Interior, where I have worked, and a 60-member federal advisory committee. The assessment was also subject to public review and comment before it was finalized. So it's quite a document. It's an amazing resource. I encourage you to check it out if you haven't already. In the context of water and climate change, the assessment highlighted 11 key messages, and you'll see those reflected in the images and data I'm going to share with you today. And they're all things that you've heard before, I think, in the context of water and climate change. Climate change is already causing and will continue to cause changes in rain, snow, and runoff patterns. Droughts will intensify, flood risks will increase, groundwater availability is being and will continue to be impacted, including subsidence that we're seeing in California. Coastal aquifers and watersheds will be impacted. Inland lakes and rivers will show increased issues with water quality. Water demand will change and increase in regions that already experience water scarcity. Increased drought cycles will affect water supply availability for human uses and consumption. Floods will have negative impacts on people and communities, including economic impact. And then these last two are the two that I am the most interested in. Water resource managers, those folks in agencies that manage our water supplies, will face new challenges and need new tools for addressing water allocation decisions. And then the last, legal and policy systems will need to have increased resilience and enhanced adaptive capacity to deal with change. This is really connected to some of the work that Robin Candace Craig has done at the University of Utah on non-stationarity. The idea that hydrologic variability in the past, there was variability in the hydrologic system, but it was stationary within a range that would allow us to predict and manage inside that range. She's written an article that's called Stationarity is Dead, which means that that predictable range, that hydrologic range that we've relied on in the past, that water managers have relied on in the past, is no longer there, right? It's moving. So we're in a non-stationary time, which means that the translation, I think, is unpredictable patterns of precipitation, more water in some places and less water in other places, more water extremes and difficulty in managing that resource. So let's look at a little bit of the data. This is projected changes to water withdrawals without climate change. This is from the National Climate Assessment, and with climate change. And you can see the percent change in just this is expected withdrawals, the amount of water that will be withdrawn. And you can see this is not just a Western issue, right? This impacts the vast majority of the United States. This is I find to be a really interesting map because this has a really profound effect on drought cycles, and that is the change in the maximum number of consecutive dry days. So how many days areas go without rain. And you can see the increases, the percent change in expected maximum consecutive dry day periods. And then the last one, it's a little bit difficult to see, but I think you can make it out. This is projected change in soil moisture. And again, this is connected with how moist the soil is, its capacity both to recharge aquifers, provide habitat, also to grow crops and all the other things that we rely on water for. Most of you probably followed last summer the California drought. Maybe you did, maybe you didn't. We certainly in the West did. Here are some images. This is a map of California from last summer, and you can see that the majority of the state is indicated as being in exceptional drought. The worst rating that the U.S. Drought Monitor provides. That's the maroon on the map. You'll also notice that that's the breadbasket of California, where the vast majority of agricultural production occurs in California. Exceptional drought is beyond severe, beyond extreme, into exceptional, meaning that it represents year over year of decreased water availability in the state of California. This image is maybe more telling because it shows the trajectory, the trend over 3 years, 2013, 14, and 15 in California. And you can begin to see the difference over time. This is April 22nd in 2013, 2014, 2015. Now, this could be, some people would say, this is the kind of variability that we've always seen. Droughts are not new, right? California has certainly experienced drought cycles before. But I think beginning to look at these kinds of images, we can take into account, when we take into account the earlier images from the National Climate Assessment, we begin to get a picture of the increasing need to get serious about the kinds of tools and mechanisms that can be exercised to respond to change. If you want to meet a group of people who don't deny that there are changes to the hydrologic system with regard to water availability, talk to those folks who manage dams. I'm not a big fan of dams, but I spend a lot of time trying to figure out how to get them out in certain places. But I've spent a fair bit of time talking to the folks who manage those facilities, and they will tell you, they have told me, they're experiencing conditions that they've never seen before. They're outside of that stationarity. It's non-stationarity. So they don't they're outside of their predictable patterns of the past. Jerry Brown said in May of this year, now we know that drought is becoming a regular occurrence and water conservation must be a part of our everyday lives. The Pacific Institute has described this as the West's new normal. Here's a look at 2016. There has been some relief. You've probably heard in the news, some people are declaring that California's drought has come to an end. No worries, right? Well, this is 2016. That, if I lived in California, that 2016 map would not make me think no worries. There is less maroon, but there certainly is still exceptional drought in the state of California. This map, and I promise I'll stop with the maps here soon. This map shows projected change in precipitation from 1950 to 2000 compared to what is predicted for 2021 to 2040. And it shows the percent change. Where it's darker blue, increases in precipitation, where you see orange, yellow, and white, decreases. So keep this image in mind. Now, this is just from one model. This was some early work done in 2007 out of Columbia University that just used one model. One of the challenges, and it's reflective of this idea of non-stationarity, is that when you just look at precipitation, you get a lot of variance. It's a little hard to predict, but this is one model sense. So just notice the colors. Keep your eye trained on the southwestern United States in particular as we look at just a few more images. These are some additional climate maps that are prepared. This is a look at averages over multiple models. And you can see it shows wetter areas where you might expect drier areas. This is part of the non-stationarity problem with regard to precipitation. It's why things like consecutive dry days and soil moisture, I actually think, are better predictors of where we'll face scarcity. This map is one of my favorites. This was prepared in 2003 at the U.S. Department of the Interior. And if you recall 2003, at the Department of Interior and with the U.S. in American politics, this is when the presidential administration was scrubbing the word climate change from documents. Despite this larger political maneuver, serious water managers at the Department of Interior, where I worked, including those at the Bureau of Reclamation, were looking at the risk of water supply crisis in the western United States. So while the administration was not speaking about climate change, the agencies were doing work to identify water supply risk areas. I love to say about this slide, call it what you like. Call it climate change, call it water scarcity, call it risk management, call it drought emergency, or call it a water supply crisis. The map tells us the same thing. So this is an example of what the Bureau, at least in May of 2003, in an administration that didn't want to talk about climate change, thought about potential water supply crises in the US by 2025. This is an NRDC study that came out in 2010 showing potential water scarcity, water scarce areas with no climate change and with climate change. You can see the same pattern. Now take a look at this. This is just raw 2010 census data with a population. And you can see where the population in the United States is as compared to those earlier maps. And then this is the last one. This is net migration between counties between 2007 and 2011. Orange and yellow represent in-migration, essentially counties that are growing in population. Blue and white coding represents counties that are declining in population with net migration out. The largest growing cities in the West still are Los Angeles, Las Vegas, and Phoenix. Look at all of those maps. I lied, one more. This is just a precip map that if you've studied water law, you've looked at before. This is rainfall in the United States with no effects of climate change, what we see in terms of precipitation. This is from 61 to 90. And again, you see a pattern. I love this map and find it so interesting as a way to talk about water law, because water law has evolved in ways that are really consistent with what we see in this map. Water law has recognized things about the natural conditions and the availability of water that makes Eastern water law and Western water law look different in the United States. The East is governed, as those of you who have had water law and are familiar with this know, by riparian principles, the West by prior appropriation. And that difference ends up being really quite significant, particularly in terms of the way the system responds to drought and scarcity. So let's talk about that for a minute. The line is generally the 100th meridian. Those states to the west of the 100th meridian follow the appropriative doctrine. Those to the east follow the riparian doctrine. And here's the difference. Don't tell my water law students, but the next two slides are all you really need to know about water law. No, you need a full multiple semesters of water law, but this is it right here. So in the Eastern United States, in a riparian jurisdiction, the allocation of water, that is your right to water, to use water, your water right is dependent on being a riparian landowner. So in this image, C and B have water rights because they are riparian to Sample Creek. So if you want a water right, if you want to put water to use, if you have an industry for which you want to use water, then you locate yourself as a riparian and you have a water right. In times of shortage, drought in the eastern United States, the shortage is shared among everyone. So everybody reduces, the theory is everybody reduces their use in equal measure, to the extent that it's even necessary to adjudicate out that sharing in the East. Oftentimes, eastern states don't adjudicate that sharing. This system has worked relatively well, although it's starting to be pushed and stressed. I think you increasingly see eastern areas struggling with how to deal with allocation questions in the face of drought, and it's really a challenge for them because they don't have a system that was built on shortage. They have a system built on availability, that riparian lands are generally available and that water is generally available. So there's been plenty of water to meet human demand, and there's relatively widespread access to water. Whenever I go someplace, of course, I check out water, how near I am to water, where the water is around where I'm at. I have found Vermont to have lots of lovely riparian parcels in my time here. But you can see that the availability of water that was reflected in that precipitation map also affects the way the law was created. As white Americans moved west, these riparian principles were brought as well. Prior appropriation it wasn't like existent in the Western United States at the time that white people arrived. The white population moved and brought those riparian principles with them, but they soon discovered, because of the differences in precipitation patterns, that riparian law wasn't going to work all that well. And they invented an allocation system that we now call prior appropriation. And it was that precipitation map, when you look at it again, that reflected that. You had less precipitation. If you looked at a map of river systems, you would see the same thing. I had to take some maps out, so I took that one out. Fewer rivers, more land mass between water bodies. And so why did riparian law not work well in the West? Because there wasn't as much water, and access to that water was more limited. So as a result of these natural hydrologic conditions, water law evolved really differently. Rather than a system based on riparian land ownership and sharing the burden of scarcity amongst everyone, we end up with a system of prior appropriation that recognizes the superior right in the person to divert water out of the stream and put it to beneficial use, regardless of whether they're riparian or not. So you get this map. You get situations where the water right holders on the system are not necessarily C and D at all, but instead A and D, because they're the ones who have diverted the water and put it to beneficial use. This idea of putting it to beneficial use, I think, it holds the key to responding to scarcity in the West, because government defines what beneficial use means. State legislatures get to define what beneficial use means, and that definition of beneficial use can change over time. It's nimble, it's flexible, it's not rigid. So this is prior appropriation, beneficial use without waste. A water user has to show in the West that they are putting water to a defined beneficial use, something the state says is beneficial, without waste. It's often said that beneficial use is the basis, the measure, and the limit of the right. And I love that saying because it captures so much. It's the basis of the right. You don't have a water right in the West unless you are putting it to a beneficial use. So you have to go through an administrative process in every state to establish that your use is beneficial, and states have over time changed what that definition is. It is the measure of your right. Your right does not extend beyond what is needed to carry out a beneficial use. It's beneficial use without waste, without wasting that water. And it's the limit of your right. You cannot use beyond what you are putting to a beneficial purpose. So that concept of beneficial use is where the system has give in it, that I think is so important. It's one of the places where there's give, and I think that's so important in the face of scarcity. The second principle of prior appropriation is first in time, first in right. The first person to put the right to beneficial use has the superior right. So if you look at the image, if you started using water in 1970 and you were upstream, but there's a senior user downstream who started using water in 1910, you have to let, as a 1970 user, you have to let water flow by to the 1910 user until that user is fully satisfied. Now, many have written about how the system doesn't actually operate like this. There are many critiques of that. So in application, this diagram falls apart pretty quickly. But what I want to emphasize today is the whole reason that we ended up with a system that even tried to set up this kind of priority is that from the very beginning of trying to allocate water, there was a recognition that it was scarce and that there was not enough for everything that we wanted to do. Scarcity was at the foundation of it. And then the third principle is use or lose. If you don't continue to use your water right, you abandon it or you forfeit it. And again, because water was so scarce, the law recognized that no right existed if you were not putting it to beneficial use. Very different than Eastern riparian law. So what does beneficial use actually look like? This is Oregon's definition. And like I said, this is where I think water law has a lot of flexibility. I've highlighted some phrases for you. Look at that and think about if you were the director of the Oregon Water Resources Department and you were facing a drought emergency in the state of Oregon, where you would think you had room to move based on this definition of beneficial use. So what you can see here, there are the typical ones that we see in Western water law: diverting water for irrigated agriculture, municipal and industrial use, household and domestic use, urban use. You can also see, though, a break at this point in the definition into things like pollution abatement, in-stream flow, recreational values, hydropower, things that you don't have to take water out of the stream. That is a place in Oregon where the definition changed in the 1970s, right? You can see legislatively where they added in-stream flow provisions, right? Recognizing beneficial use where you didn't have to divert water. So it has changed over time. So there's been this evolution in the notion of what beneficial use is. When society's needs have changed, the definition of beneficial use has changed. We've altered this definition. So think about, now add to that it's beneficial use without waste, and read the definition of waste. And think about, again, if you were the director of the Oregon Water Resources Department, how you might use this definition to respond to drought. So this is one of the places where I think existing law has the kind of flexibility and resilience to respond to change. Now, it is pretty ironic, for those who know me, that I am standing up here defending the doctrine of prior appropriation. And I don't want to create too much of a rose-colored picture of prior appropriation. I certainly understand, and I largely agree with those who have identified the disadvantages of this kind of system. As it has been implemented, and that's an important phrase, as it has been implemented, it seems like an antiquated system that locks rights into place. It protects old and inefficient uses of water over time that end up having lower social and economic value. It's been criticized as rigid, lacking flexibility to address change over time and place. It creates the wrong incentives by encouraging people to use water when they don't need it because they're afraid they're going to lose it under the use or lose principles. There's no built-in mechanism to reevaluate water rights. And it creates, perhaps most dangerously, I think, in some people's minds, it creates expectations of private property interests. Now, I disagree with that creation of that expectation. And John Echeverry and I have spent many hours talking about that, and he's dedicated much of his life's work to this question. But that is one of the criticisms of the system, and you can see that there's plenty to criticize. But I want to look at the advantages of it, right? Because as I've started to think about how to build resilience into our legal and policy system and give water managers the kinds of tools they need that are clearly called for in the National Climate Assessment, I just committed myself to taking another look at prior appropriation. And I started to see some possible advantages. And I've done this, I think, largely because I have started to ask myself, as an academic who has the freedom to sort of sit in my office and imagine whatever, some people would say harebrained theory that I want about whatever, I started to ask myself, largely because of a conversation I had with Mark Scolacci at Colorado, what if they come to us and say, okay, what do we do? We actually have a crisis now. What do we do? Do we throw out prior? If the Oregon legislature said to me, okay, fancy pants, smarty pants about water law, what do we do now? What do we do? Do I say, scrap the prior appropriation code, change it, all new law? Or do I have something else to offer? Like, in really serious terms, what would I say? Do I have an answer to what to do? And that's what brought me to this sort of political reality of whether we could ever throw out an entire allocation system in the West in favor of something else, or whether there are things about prior appropriation that could help us navigate through the challenges and how to talk about those. I think of Aldo Leopold a lot in this work, that to keep every cog in wheel, right, is the first precaution of intelligent tinkering. So here are those advantages. First, it's built on principles of shortage. So from the beginning, from its earliest days, we have a system that recognized that there was not enough. Dan Tarlock observed in 1991 that the prior appropriation system in theory has great potential to cope with global warming's impacts through risk allocation, because it's premised upon dealing with water shortage. That's its premise. However, in practice, as I said earlier, as it's implemented, prior appropriation has actually operated to minimize that risk through non-enforcement of priority storage facilities and groundwater pumping. The result, according to Tarlock, is that there's little expectation among users that the risk allocation mechanism, cutting off a water user's water supply, will actually be used during shortage. But this is changing, and you only have to look at California this past summer. The realities of the hydrology and the precipitation and the demand for water resulted in more calls on water and a tremendous number of water users being cut off. That was the controversy. Folks, water was shut off, even in Hollywood, right? They lost their ability to divert water. But this alone, this premise on shortage, doesn't really get at this idea that do those beneficial uses that have been recognized really get at the kinds of water use that society wants to protect. The critique that prior appropriation protects and locks in old, antiquated uses. And that's where this idea of beneficial use without waste becomes so profound. The idea of beneficial use without waste is malleable, not rigid or fixed, and it can change in response to society's interests. This is a place where years ago, folks like Jan Newman, who taught water law at Lewis and Clark, started advocating that using this provision of water law, this idea of waste and beneficial use, was a key to have law serve society's needs. And we've done it before. We've done it when we wanted to recognize in-stream flow. We've done it as new uses have come online. It's often thought of as a bit of a political third rail. You know, you can't touch the definition of beneficial use. My own experience is that as shortage and drought and scarcity are occurring in the West, suddenly it's not thought of as such a third rail anymore. And there's increasingly a willingness to entertain changes to the definition of beneficial use. Another advantage, and I think a lot of people don't understand this about the prior appropriation system, is that there is a transfer process to move a water right from one use to another use. Every state has a transfer process. That's an administrative process. It's not a private property market transaction like how you sell land. It's an administrative process where the state agencies are involved. And in that process, states can reevaluate the water use. They can look at the public interest. They can look at the rate and duty of a water right, how much someone's allowed to divert. So there's an administrative mechanism there in place that could address the change. That's really different from the East. In the East, your water right, if you buy a piece of land, you become a riparian, and that water right transfers. And then finally, this idea that I think is so important about the public nature of water in the prior appropriation system. And this really gets lost, and this is so important. In fact, John just shared an email with me over the weekend about the Republican Party's platform, where they insist that a water right is a private property interest. This is an important issue to watch. That question is not resolved in my mind. We have not decided in the West whether or not a water right is private property or not. And that's why this is so important. And I think that this gets lost in talking about water rights. So I want to offer just a little historical reminder about the movement from a riparian system to an appropriative system in the West. As the Western states entered the Union and adopted their appropriation codes, there was considerable debate about the fact that this was moving from a property-based system that you had in riparian jurisdictions. And by the way, the emergence of the regulated riparian doctrine is the response to this in the East, this concern about a private property system. From a private property-based system, where water rights are based on land ownership, they're a stick in the bundle that comes with your land, to an appropriative system, an administrative system where land ownership doesn't guarantee you anything. You have to go to the newly formed state government and ask to use water for a beneficial purpose. And those rights were established separate from land. That is not a system rooted in establishing a private property right. You would have stuck with riparian if that's what you wanted, right? Because there was shortage in the West, they adopted a different kind of system. And so while many Western states started out before they joined the Union during the statehood period with these common law systems that reflected the Eastern experience, ultimately, every prior appropriation state adopted an appropriative code that required a government agency to grant and monitor the water right. That speaks to the public nature of water, and I think that's lost in a lot of the debate about the property interest. And then finally, in every Western state, in every code, there are also provisions that allow for planning and developing strategies for water management. Oregon is a leader here with the Integrated Water Resource Strategy and the Basin Planning Initiatives. And so in this context, the department is having very serious and real conversations with water users in basins about water conservation, shifting water to other more important needs, all inside existing law. Working through these planning initiatives to reimagine how we use water in particular places. So prior appropriation suddenly has become this really important tool in the face of this change. There will always be those who advocate throwing it out, and I don't know whether it's better in the face of the kinds of change we are confronting, whether we should start over or try to work with what we have. My goal has been to look more closely and think about, these efforts, to think about beneficial use again, to think about waste. Jan Newman encouraged us to do this, as I said, years ago, and to really think carefully about what it means for water to be publicly rather than privately owned. This is a live issue in the context of takings law right now. And you have, as I said earlier, one of the best thinkers I know on this here in Vermont, John Chevarria. And Sandy Zelmer from Nebraska has written a phenomenal article on private property interests in water and whether they exist or not, and if they do, what their contours are. I find that in the context of water law, it's really interesting to talk to folks that I know who are very serious private property advocates and to watch their positions soften a bit, like my family in mid-Missouri, when it comes to water. There's something about water and its essentialness that causes a pause in terms of fully privatizing it. And I think that's a really important piece. So here's what I'd like to leave you with today. Think about water law and policy, forget the slide, as being dynamic and active, not rigid and movable. That water law might promote resilience and adaptability in ways that we never imagined in the face of change that we never imagined. Many of these provisions, beneficial use without waste, the transfer process or public ownership, have always been there in the water codes. They were there from the beginning in the Western states, but we've not had to use them. I have argued that the kind of change we face has made these principles suddenly less controversial. In fact, they might become the very tools that water managers need to navigate our society. Because have no doubt, when the water runs out, people will turn to government and ask government to figure out a response, even those that think government is bad and doesn't function well. So the theme for both lawyers and law students in the room, and oftentimes I think lawyers and law students are the folks you think of after the fight is underway or after the bad thing has already happened, because you want to bring the lawsuit and somebody needs to pay for what has happened. But I would offer that to think of law much earlier in the process. Think of law as a way that society chooses to organize itself, and that there are these principles embedded in the law, and we can deploy those proactively in looking at what the science is telling us, what our legal and regulatory and policy structures have in place, and how we can deploy those. Lastly, leave you with the notion that various decision makers, whether they be courts or heads of state water resources department or water districts, that they think carefully about this private versus public nature of water. As those issues are pending in federal and state courts, the Klamath case, the Klamath takings case has bounced to the Oregon Supreme Court and back up again. We have a justice on the Oregon Supreme Court that wrote a fantastic concurrence in that case that I would commend to all of you, where you can see her nervousness about recognizing a private property interest, recognizing a water right as a private property interest. And I think that kind of cautious and thorough and careful jurisprudence around this question is really important. So I'd just like to close with a quote from Jan Newman, one of my mentors. Droughts are a new normal. In fact, more drought in the future is likely. We need to manage our water resources with that in mind. That means expecting and planning for scarcity, decreasing our vulnerability as much as possible ahead of time, reorganizing and readying ourselves and our laws for drought when it's coming, and responding with as much flexibility as possible, allowing water to move freely to essential and valuable uses while maintaining the environmental baseline of water in place. So there it is. That's our task within the existing water code. So thanks for listening, and I think I've saved enough time for questions. Thanks so much.
Do you have any advice for us Easterners?
Yeah.
We have a riparian system, and we in the East, even in Vermont in the summers, but particularly in the Southeast, are facing, as you mentioned, increasing risk of shortages. And so how do we build from a riparian system to a system that is more adaptive in a time of drought?
I think it's regulated riparian law. So many states, as they've faced shortage, have done exactly what happened in the West. They've moved from a property-based regime to an administrative regime. And so suddenly water rights in a regulated riparian state are a function of getting a permit. That permit is time limited. The state can reevaluate that water use. I mean, it's a public process, a government-based process. Now, it flies in the face of all those that are concerned about government intrusion and intervention and more government, but that's the shift you've seen as states have tried to address this dynamic. And I think that that's the key, is to move away from thinking about water resources as fully privatized and move into thinking about them as a public resource where you make tough management decisions about how water gets used over time. So that's my advice, is to follow those developments of a regulated riparian system. That's certainly what happened in the West in the face of the scarcity that was there from the beginning. And then watch this public-private. For me, I don't think there's anything more important than this private versus public nature of water that's happening right now, and the trends around that. And so paying attention to that and being strong advocates, I would say, for the public interest in water is very important. So yeah, Melissa.
Are your concerns about that public versus private rights in water mitigated by states that view those rights as overlapping in the same water and private rights being subservient to public rights?
Yes, yeah. I actually, if I had all the time in the world, would love to talk with you all about, I think one of the key things when you look at this public versus private, when you look at, I've looked at so many of the cases in this area, the really important question to ask yourself is, who is your private right running against? So if you and I, Melissa, have private rights to water, and we're competing against one another as private citizens, I'm okay with that being a private property right, right? And if mine's senior or whatever the law says, whoever, yours is senior, the law gives you the superior right. As between you and I, if we're fighting on our property line about who gets what water, great. I think that's a fine place for a private property sort of idea to take hold. I don't think that the private property interest should run against the state, right? That as between me and the state of Oregon or me and the state of Vermont, the state as it represents the public interest should have the ability to alter the use of my right, right? So where you can have that public and private system overlapping, that doesn't concern me. When you look at some of these takings cases that John has worked on and that I've been watching, That's not what's going on. They are talking about a private right as against state decision makers, right? And that's why those cases are being brought in the context of takings law. So does that answer your question?
Yeah, and I think, we have some really good state Supreme Court decisions.
Right.
Give an example that would highlight how how private rights are subservient and always lose.
That's right.
Vis-a-vis public rights, and that there is no taking claim.
That's right. That's right. Yeah, and so that's what frustrates me about folks who, including the author of the water law textbook I use, who I have quibbled with, Buzz Thompson, several times about why he does this. You open up the chapter on prior appropriation, it says, water rights are private property interests. I'm like, don't say it that plainly. That, so you have all these people walking around thinking they're private, but when you really dig into this, they're not private at all. There's plenty of precedent in many states for that public, that there's something public in the nature of them that overrides it. I would argue that the very notion of beneficial use without waste is the public, right? It's the public saying, yes, you can use this water, but just so you know, as a public, we have the ability to revisit this water use, right? It has to be beneficial. It cannot be wasteful. You cannot sit on this right if you don't intend to use it, right? And so I think there's plenty of examples in the law where that public nature comes through. The work that's been done for years around the public trust doctrine is one of those areas, but I think there's work to be done even outside the public trust doctrine, just in the very nature of some of these water codes. Yeah.
So just because it's always fun to be a contrarian.
Yes,
so,
thank you.
I hear the voices of all the economists that I've ever studied in my head saying
yes,
that
I love economists.
The more you make this public, the more you're actually simply creating a tragedy of the commons, and that actually the solution is to privatize it even more. And
so you can set a price on it, right?
Essentially set it up for auction.
Because we
that
all,
definition will always lead
that's right.
to beneficial use. And yes, there are going to be co-CN transaction costs. So you do set it up as an administrative system, but basically the government is mostly there to make certain that those deals occur.
Yes, my economist friends on my Willamette Water 2100 project, which I was trying to pull the slide up for, I work with economists, and I've come to love economists. I don't know if they love me. I don't know if they love me, but I love the economists. You don't have to fully privatize it to fee simple absolute property rights that result in takings claims in order to have a market in water rights permits. That you don't have to take it to fee simple absolute. You can have a permit trading system. We have them all over the place. Economists brag about them all the time and talk about how they lead to efficient results, right? And so, that's my first response is don't take it to its logical extreme if you're going to go that direction, right? We can have a permit trading system without establishing fee simple absolute property rights. Part of the problem is we use the word property to do too much, I think, in American law. Because we have property in the due process clause, and we have property in the context of permits, and we have property in the takings clause. And I actually think the word property is doing different work in those different contexts, right? So if you have a water rights permit and the state wants to take it away, do I believe it is property for purposes of due process? That there should be a process for you to be deprived of your water right because you have a permit? Absolutely. Do I think that means it becomes a fee simple absolute property right that is the purview of the takings clause? Nope. That's where I would draw a line. It's something different, right? And that's part of the response. The other response is just the classic, I know economists, and some of my best friends are economists, and Bill Jagger, if you're watching, that one was for you. This idea that we all vote with our dollars, and that there are these markets out there that represent these free markets that work in these magical ways that we talk about. I just haven't seen one. I would love for somebody to show me one where that idea is actually playing itself out. And I think it's really risky to test that perfect idea in the context of water. I'd like to pick another resource. Let's pick cans of corn and see if we can generate this beautiful market that we all love in the context of cans of corn. And if it works in the context of cans of corn, if we get it figured out with cans of corn, then we can try water. But let's not experiment with water. So that's the other response I have. Thank you for that question. As you can tell, I love answering it.
Since you brought up corn,
Yes.
if government does come to you and says, what do we do?
I would not tell him to privatize it.
In your response
Yeah.
to the government, do you say we need to reconsider agriculture as one of the beneficial uses of water, or we need to reconsider what types of agriculture
Right.
and eliminate that from the category of acceptable uses for beneficial use of the
Yeah, so this is fascinating. So you didn't block me from this side. No, they've left the room, so I didn't trip over wires. In California right now, California is fascinating to watch right now, because in California, it used to be that the fight was always between people who wanted to protect in-stream flow for fish and people who wanted to divert water to grow crops, right? And that fight still exists. I mean, that's San Joaquin, Bay Delta. I mean, we do this all the time, right? But there's a new fight emerging in California, and it's within the agricultural industry. It's not the environmentalists versus the agriculturalists. It's the grape growers who are junior versus the almond growers or the rice growers or the cotton growers, right? And the fight is, wait a minute, really in the context of beneficial use, we can't have a conversation about which of these industries uses water most efficiently. We're only going to do first in time, first and right. Isn't the definition of beneficial use big enough to have us look at things in a public policy context through our state legislatures and our administrative agencies, whether or not things like how much water you use for a crop, the value of that crop on the market, right? Let's talk about markets. Let's talk about the value of those crops, those water-thirsty crops that have senior water rights that we grow, and then we plow them under because there's a glut of them in the market, and we can't move them into those places, right? So suddenly we have inside of the agricultural industry, but this is what I mean when I say something that historically was thought of as really politically controversial on the third rail, and just the stuff that environmentalists talk about, right? Within the ag industry, they're talking about this now. That doesn't this definition of beneficial use without waste mean that we can get at these very questions? So I'd say, if anybody asks me, start having those conversations and open it up between the ag industry. I think some really interesting things would come out in the context of the ag industry.
Well, we should end on that so people can get to their classes. So thank you.
Thank you all.